What I've listed up here are the three main areas that we see in relation to trusts causing heartache to advisors initially, but ultimately to end user clients with the succession of control of the trusts. And this relates to, I've referred it to principal, there's a lot of different names. Often people will refer to it as an appointor, a guardian, whatever it might be. How the succession of that role takes place is fundamentally critical and needs to be very near the top of your checklist when you come to look at the handing of control. So in this case study, we're just going to ignore the fact that there's a corporate trustee and just accept that it is what it is. Our sense is that most trust instruments will fall into one of three categories. They'll either provide no mandated succession of the appointor role at all, or the principal role at all. So in other words, if the principal dies or loses capacity, it's just silent. And unless you've gone and implemented other documentation, nothing will happen. The next big risk is that there is a level of literature around what that control looks like, but those rules only apply in relation to the death of the principal or appointor. And our big concern there is, particularly as people are getting older and older, is that, well, what if there's incapacity? And what if that incapacity lasts for many, many years? How do we regulate the succession of control if the trust instrument on establishment only deals with the death of the principal and not their incapacity? And the last big problem, which goes to the mantra that all of you hopefully have, and part of the reason why you're interested in a discussion like today, is that the trust instrument's just not even read at all. So there is no understanding by the advisors or the end user clients as to what's going on because they've not actually read the trust instrument to know what the answers are.